Good morning, everyone. Hope we are all doing good. Last week, when we met, we discussed issues regarding legal and ethical issues in counseling. Today, we shall talk about dealing with clients after getting to know what to do, what not to do when you are in a therapy. We need to know the individuals that might be in our therapeutic rooms that demand what we should do to them, how we should handle them, in order not to fall into any ethical dilemma. So we are going to talk about dealing with children, adolescents, and their families. We have unique legal and ethical concerns in as much as these groups are concerned. So when we are dealing with a child, we have what to do. When we are dealing with an adolescent, we have what to do. When we are dealing with a family as a whole, we have what to do in order not to breach any ethics. These ethics, however, are not generally emphasized in most of our ethics courses. As we are trained, we don't indicate them, but as you start to practice, all those things come to be. So we shall talk about informed consent, confidentiality and its types, how to share information, and in the case of law, how someone can be subpoenaed. So I think subpoena, when you get to subpoena, Beatrice will be the best to offer us views regarding the processes to subpoena. Others will say subpoena. It all depends on where you attended your primary school. We have other important topics that we shall discuss. Importance of a counselor competencies, how to engage people from different cultures, that is multicultural counseling. And we have other topics in terms of you cuddling the individual when it comes to touching, the counselor, how to touch. And a counselor in a divorce situation, assuming someone comes to your facility being divorced, how to handle yourself in order not to be someone that will try to take advantage of the person's vulnerability. We shall also think about the law that are computing and social media and how their usage can enhance our counseling practice. In fact, laws that are typically higher or coarse, they vary from individual country to individual country. Laws are not the same in the various jurisdictions. However, there has been little guidance in mental health literature about the ethical issues that may arise when it comes to counseling minors outside the school. Although we may have these things in the books that we have offered you or the courses that we have pursued, yet they don't make them so succinct or explicit. Meanwhile, you have a potential legal and ethical issue when we treat young ones. The common concerns that we raise when dealing with the young ones are the child's right to confidentiality, the informed consent, the children and the divorce, the use of touch, the counselor's competency, and the multicultural issues. One of them is the privacy. Remember, privacy is about secrecy, keeping things out of any other person's view or any other person's accessibility. So privacy refers to the client rights to choose who has access to the information that they have. You, the counselor, even after engaging the counselee or the client or the child, you don't have any right to give out the information to anyone. And the child has the right to tell you that my mother or father can have the right to my information. If they don't give you the right, nothing can bear you to do it. Nothing can push you to do it. You must keep it to yourself until the appropriate time given by the client, being the child. So parents don't even have it. They don't have the right. That is why even in school, when your child performs, you don't have the right to force the child to give you their end of semester score, but you can lobby from them, although you pay the school fees. That is how it is. So this includes signing consent releases of information. Sometimes you need to sign a form. So about deciding, you can also take a decision about protecting the child. And the privacy is one of the things. Confidentiality is one of the things. Informed consent is one of the things. When they sign, it means they are obliged to let their information out when they need be. So confidentiality, it is a foundation on which counseling is built and lies in the ethical obligation that information must be kept private from others. Information must be kept private from others. And how does confidentiality differ from privacy? Privacy is who is eligible to access my information. Confidentiality is how secret is the information. So privacy is about accessibility and confidentiality is about secrecy. So all codes of ethics in mental health profession address confidentiality, where the information that the person has given you must be kept secret. There are limitations to confidentiality as stated by law in terms of our professional code. Meanwhile, these same laws are interpreted differently based on where they are found. So one must use a careful judgment in making ethical clearance or ethical decisions. Others must bridge it, depending on where you find yourself. In a situation whereby the law catches up onto you to bring about information of someone, we have several ways in doing that. You just don't go out and say you are doing. So let's be mindful of this. Access to attorney, familiar with mental health law, is a wise investment. So get in and understand the legal implications of whatever that you are about doing in terms of confidentiality. We also have privilege, which is the legal right owned by the client and protecting them from having their private therapy information divulged in judicial proceedings. You may be privileged to have it, and privilege is established by the state statutes. So some institution may be given the right to be able to let out that information, others may not. But remember, not all clients hold privilege. It all depends on the type of mental health issue or therapy one engage in. Basically, the law prescribes conditions for which a counselor is not subject to prosecution for withholding information needed by the court in litigation. It means, as a counselor, the law cannot force you to leave or to give out information of your client. There's nothing of that sort. You can resist it and they cannot do anything to you. You can be subpoenaed, but you can tell them it is my right not to give because it breaches upon the counselor's rights. It helps to protect the counselee. But then we live in a nation where we have right to information bill. The right to information bill is of exception when it comes to individual safety. So not everything will work out here. One of the most confounding ethical issues that counselors face when seeing children or dealing with children is what and how much information to share with parents. Some of the information, even the children will say, don't tell my father. If you tell my father, you will not pay my fees, especially when they are into homosexuality or when they are dating before being grown. Some others too, parents may have the legal right to know what occurs during their clients' counseling, but not every information must be given to them. And the degree to which they may have the information differs based on who the person is, where the person is coming from. That is why we see state by state, region by region, school by school, institution by institution. Ethically, however, many believe children should be guaranteed the same confidentiality as promised to adults. Yes, they may be children. You may be engaging them. And sometimes because we think they are children, their information cannot be understood by them. So their parents are those that must get it. It's false and it's not right. We should be able to give them the same information as we give their parents. So the setting in which the counsel occurs may also influence issues of confidentiality. Where the therapy occurs, if other people are there, it can go against secrecy. It can go against privacy. It can go against confidentiality. For school counselors, they may not have to disclose the content of the person's session they had, especially to the parents. But in a situation whereby the state allow mature minors to access treatment, counselors still have an obligation to notify parents or guardian when it is the best interest for the minor. So there are institutions whereby the children themselves will walk in for the counseling session. At this juncture yet, counselor has the right to let the parents know. Because remember, they are minors and they are under people or they are dependent, but not the right information that the child came to seek from you. But they need to be in the known that you are dealing with their children. In some situations, even though minors are legally able to access therapy for mental health treatment, they may not possess the right to authorize the release of information to third parties. In situations where parents also have access to case records, in many situations, providers can limit what is divulged or what is given out to the parent if the information will be harmful to the child if disclosed, especially for the case where the child says, if my father hears, if my mother hears, they will not pay my school fees. You don't need to disclose those information. Harm to self. Any child or adolescent who may be at risk for depression should be interviewed to ascertain if they have any suicidal thoughts, have a plan to harm themselves, and have the means to carry out such a plan. In fact, there are many situations whereby a child may be having psychological problem, and this psychological problem might be going against the child. In that sense, you need to ascertain it in order to know whether it's going against them or not, so that you can help prevent the situation of causing harm to themselves as a child. As was said, there are many instances you may breach confidentiality. That is your duty to protect and reporting issues of abuse and neglect. Their counselors often breach confidentiality when not mandated by the law. Sometimes when the issues are about abuse, trauma, and the rest, yes, even though the law says you don't need to tell anyone about what is happening, but you are mandated to go against it and tell. Because if someone is abused, rape issues, you can't hide it. You can't hide it. It might go against the person and even take the person's life. So confidentiality must be broken when there are threats of harm to the individual that is having the issues, threats of harm to another person that is living with the person, or when it is learned that in some states, the child or the elder is a victim of abuse or neglect. Usually when someone is neglected, the end product is very demeaning and dangerous to the health and growth of the person. So it's very, very important you breach confidentiality to make issues go. So when we have harm to another, even you, the counselor yourself, you can be harmed by the client. If things are not right, the client can feel that your presence, even in their environment, is something that is going against them. So they may choose to worry you. They may choose to worry and even hurt you. There are many instances, people who are mental derailed are able to beat, inflict pain on those who are trying to provide them safe haven or safe environment. So it happens. If you go to the mental homes, especially for the juvenile, the child can be so angry to the extent that they can hit you with something or even bite you. If you go to the special schools, the autistic may find solace in biting friends. Meanwhile, that person never thought of biting, but because of the situation, he or she need to bite. So if you have this as a counselor in your setup, nothing best you to tell the parents or any other person that is seeking information on that individual. So under the harm to another, we have the likelihood of harm and a special relationship that exists. Generally, a person does not have a duty to control the conduct of another, but counselors have a special obligation due to the nature of their profession. Yeah, there are instances you can't control someone's life because it's independent, but you are given the line or a sense of duty or action to operate in that tangent as a counselor. And again, it is established that counselors may receive physical harm. So if the client is threatening, some states have statutes requiring that threat actually communicated, most do not. Sometimes if someone says, I'll kill you, that person do not have anything. But those who keep quiet, they are those who act the more. And we can even align that to our environment where we live and the rest. And again, when there's a foreseeable victim, some states have broadened this condition to include unknown victims. So you, the counselor, must take reasonable steps to satisfy the duty to warn, which always includes warning the intended victim, especially when you foresee that or think that or expect that something might occur not on you, but another person that live with someone who is having a situation or a problem. So let's have that in mind. And again, as counselor, you may notify the law enforcement agencies that are close to where you are practicing in case you send someone trying to cause harm to someone. And if you hear or even see someone planning to commit a crime, being someone with a peculiar problem and you never tell, it means you have violated an ethic in your life as a counselor. And we have abuse. We have abuse. In a situation of abuse as a counselor, the laws require that you need to report any child abuse or neglect. But in most instances in our communities, we find that children are abused, but we don't talk about them. Why do we hide those things? Is it that we are afraid? Is it that things are going against us? That's the question to ask. So whenever you sense abuse in the life of a child, you need to make sure you inform the parties involved so that each and every person will play a role. And now you say, oh, is the person's child, is the person's family member. Whatever they do to the person, you don't care. You must care because it's part of your duty as a counselor to report abuse. If you don't report an abuse, it's a dent on your image as a counselor and it go against the ethics that we all try to hold up onto. But remember, in the Ghanaian community, neglect and abuse is very common. Mother abusing the children, father abusing the children, relative abusing the children, so on and so forth. And abuse about not causing only pain in the person, even denying the person food, denying the person the opportunity to have free will is also an abuse. So many counselors may hesitate to report abuse because it can permanently change or damage the therapeutic alliance, both between the counselor and the child, as well as between the counselor and the parents. Because of that, you try to shield, but mind you, don't shield it. Let it out so that the person can be helped. There are situations whereby a counselor may receive a subpoena from a court because no confidential information should be released to any attorney just for asking. So here are the series of steps in responding to a subpoena as a counselor. First, read the subpoena thoroughly. When you are being subpoenaed by a court of competent jurisdiction, you need to read the subpoena first. Is the attorney asking for specific information for a case file, for a testimony via a court or a deposition? Second, talk with the client or engage the one that is having the problem, whose information that the court is requesting with regards to how he or she wants you to handle the subpoena. Three, talk to both the parents of the child and the child regarding the dispensation of the information. So you can do a common group discussion with them so that each one will offer a view whether to let out the information based on the requisition of the court or not. The fourth one is judge may order information to be revealed in spite of clinician stated rationale for why information should not be kept. Sometimes the court will force you to do it, but it doesn't mean that you should just straight ahead and give it out. No. Some courts may allow counselors to share the privileged information with the judge privately to determine if the information is necessary to the proceeding or if public disclosure will be too hurtful to the involved individual. You can even check the court case or the parliamentary proceedings on the police conspiracy to the IGP. The sensitive one, they do it in camera. They went in, they hide, and the issues came. And finally, we got to know that those policemen were conspiring to just punish the police officer for no wrongdoing. So the same way, the judge can invite the counselor in a private conversation for issues to be cleared before, because once it's made public, it may harm the individual or hurt the person. So let's think about that. Finally, you do not take case records to court unless they are specifically requested in the subpoena. Remember, as a counselor, you record all the engagement that you have with your client. So you don't take them to court. You only take to court only when they are specified in the subpoena document. So the counselor should inform clients why it is necessary to break confidentiality, explain to them what will be revealed, and invite them to participate in this process. There are various options for managing confidentiality when it comes to children or minors. According to Hedrick 1991, he gave us 4 possible positions counselors can take, in as much as the issue of sharing an information that is specific to a child is concerned. The first is confidentiality alternative is to promise minors complete confidentiality, with the exception of what professional is mandated by law to report, such as abuse, suicidality, or suicide homicidality, and so on and so forth. The second one is the limited confidentiality, which according to Lawrence and Kepios, it requires the minor to waive or to give you the opportunity in advance, the right to know that what will be revealed to the parent or the guardian. Informed, forced consent is a third approach, which occurs when a child has no voice in what is disclosed, but is informed before the disclosure is made. Over here, the child is informed that we are going to tell your parents, we are going to tell the law, we are going to tell CMC A and B, and you can't prevent us. But the child should be in the known before that is said. Otherwise, the child can also take you on. Yes. And the fourth one is when no guarantee of confidentiality is made to the child. Here, secrets that are held by the counselor can impede individual and family work. So in using this approach, it is important that the children and the parents be told this at the onset of the therapy or before the program, so that both will get to know what is happening. And telling them can be done both written or verbally. In doing this, it increases parent trust that the counselor respects the rights to know important facts about the child, while also educating them that the child does need privacy in order to talk about whatever concerns they have. The child can be assured that not everything talked about will be shared. Rather, if something does come up, the counselor decides the parent should know. The counselor will work with the child on how to share the information and when to share the information so that they can minimize or reduce any potential negative consequence. So if it happens, the counselor could spend time discussing the child's fears, meaning you can do elaborate discussion with the child, try to expose them to the consequences that may emanate as a result of the disclosure, so that the child will not have the feeling that when it is out, it will go against me or that. So the success of these efforts often depends on the degree to which trust and quality of professionalism is exhibited between the counselor and the counselee, the counselor and the child. So counselors have a lot to do when it comes to dealing with children. The fifth position is that the counselor may work with the parents and child to come up to a mutual agreement in as much as confidentiality is concerned. So they will be thinking about how to let the information out. For example, parents will want to know about an adolescent sexual activity, others will not. But in a situation whereby the sexual activity of the adolescent is very bad and weird, there's a need for you, the parent, to be able to do that. There's a need for you, the parent, to be able to do that. Assuming a child has homosexuality intent or has been practicing in that child might not want anyone to know. But then, as the customs of the nation demands, it is possible you let parents know. So after going through the process, what would you do as a counselor? You need to engage all other means for a substitute of the behavior, because it doesn't mean the person is bad, it's the behavior that is bad. So you, in your own way, you can look for the precursors to that behavior. And if it persists, then you can start to say, okay, let's meet parents so that we all can come together to do it. At first, they may resist. Subsequently, they will oblige. Then you all come together as a group to help the child from that situation. And use of alcohol. No child that drinks will tell the father or mother that they drink. But when they come to your facility and you identify alcoholism has been their problem, you can engage them as a family for it to be worked out. Finally, some counselors will set up a best interest agreement with the child and parents. And the best interest, what will help them to be out of the problem they may be encountering or the situation they find themselves. And that is the best of all in whatever therapy you engage a child in. So you all come together in agreement, you come up with it, and the child follows it. The limits to confidentiality in this agreement are set up by the counselor, him or herself, and the children, at the same time, the parents, and leave the decision to share the information only with her. It is agreed that confidentiality will be maintained unless the counselor believes that the child's best interests are not being served in relation to their health, welfare, and other significant relationships. We also have group confidentiality. Group confidentiality. And this group confidentiality, it is about the group being engaged in a counseling therapy, and whatever information that they share with you must be kept as secret and not being shared anyhow. So complete confidentiality in group counseling is harder to attain because individuals come in with different mindsets, different ideas, and different motivations. So time and care must be taken to explain the concept of confidentiality among them. Many instances, you come as a group, you discuss something. Before you say Jack, one of you out there has already gone out to divulge the information. And that's one of the issues that come up when it comes to group or maintaining group confidentiality. So children should be encouraged to consider potential limits of confidentiality before disclosing very personal information during group counseling. Sometimes you even tell your colleagues that you are having, let's say women, you're having a particular problem with your reproductive system or your reproductive issues. You end up hearing it from another person and you ask who said it. Oh, I heard it from this. Confidentiality is breached. And that is one of the things we are talking about here. We have informed consent. Informed consent is very, very important, and it's a permission given by a client. That's signal the beginning of a therapy or a contract or an arrangement between them. So clients need to give informed consent freely after being appraised of the risk and benefits of whatever engagement that they have, especially those in research. Before you collect information from anyone, you let the person sign informed consent form, meaning they have obliged and agreed to be part of the process. So the binders may contract you, the professional counselor, either by having a parental consent, involuntary or voluntary, through a court of order. So informed consent in all of these cases can alleviate or can let out any misunderstandings and decrease counselor against any potential liability issue. In issues where the families of the child are no more together, divorce, you can see the issue of taking care of the child. Obtaining informed consent is always difficult because you wouldn't know whether you are going to the father or mother. But then when it's for the child, the interest of the child, they too, whether they diverse on ideas, should come together for the good of the child. And you, the counselor, is the one to make sure you harmonize them so that the two of them will agree to whatever that is happening. So in obtaining informed consent can become a contentious issue if the parents are recently separated and custody of the children has not yet been decided. So there is typically a provisional order outlining temporal custody. We have the role of a counselor in this process. The role of a counselor in this process. So your role as a counselor in this process is to make sure the most one area in which counselors are most vulnerable to charges of ethical misconduct is when working with the children and families of divorce. Often, the parents are locked in ongoing bitter legal battles over child custody, visitation, support, payment, and myriad of other post-decree issues. So divorce and post-divorce situations are often emotionally charged and can put children into destructive loyalty conflicts. The father is saying this, the mother is saying that. So the child finds itself in a tangle, and you, the counselor, find yourself in bringing the diverse ideas or diverse individuals together for a purpose to improve upon a problem that is found in a child or the minor. So counselors, in a way, should learn issues of law so that they can handle such situations. But then, Woody, 2000, page 74, gave us this. That the rules outlined by the Woody 2000 on the book, page 74, says, the treating counselor for the child, parents, or family. This could occur before, during, and after divorce. And again, the evaluator in the custody dispute, meaning you, the counselor, evaluating the psychological character of the relevant adults, the guardian and litem for the child or children, the mediator to resolve the dispute between the child and the parents or the parents, and the expert critic. You are the one that can critic. So here you wrote that you treat, you evaluate, you guard, you mediate, and you criticize intelligently. Bartlett also gave us several suggestions for working counselors. First, clarify your role with the child and the parent. Second, emphasize to the parents the importance of focusing on the child welfare and not their individual interests as parents. Three, establish grounds that if an evaluation is done, discuss to whom it will be sent to, emphasize it, and establish it as well. So it is suggested that doing this whenever families with children are seen, as any couple could decide to divorce at some point in life. Sometimes in a therapy, you may be using touch, meaning using your palm to hold someone and then try to let the person be comforted. Sometimes you may do that more dangerous. And in that sense, you need to be very careful. Some people will not be happy when you touch them because it may be sexually seducing or it may be sexually harassing. Some of the counselors, especially the male counselors, they may be touching the female when they come in. And when you touch, sometimes it can be erotic in nature. When I say erotic, it can send signal in terms of sexuality. Let's be careful with that. So you ask yourself, what are the possible benefits of the touch? Is it for the person to be comforted, or you have any peculiar reason or any motive that is beyond the reason why they came to your facility? If the touch could enhance their self-esteem, you are free to do that. What considerations are related to the counselor? Whose needs are being met? Is the touch genuine? Ask yourself. What safety issues are related to the child? Is it harmful to the child? Does the child have a history of abuse if touching was used? If so, child could be alarming. Abused children have trouble of separating the fact from fantasy. What is this child family background might be? And again, what are some practical considerations? Does culture allow you to touch them? If you go to an Islamic country, touching is an abominable act, and they wouldn't allow you to do it. So use of touch in dealing with children. At the onset of the therapy, you need to discuss that with the child so that they will know that this might occur. Parents should be informed as to how touch might be used. If you don't do it by accident, you don't do it by accident, or you don't do it without telling them. In many instances, we may see cultural issues emerging in a counseling situation. So when seeing children and their families, the context of the culture should be assessed before making therapeutic judgments and interventions. So most often, first, most family therapy models emphasize individualistic orientation, helping the members to achieve independence, individuation, identity, and self-esteem. So let's take all this and guide ourselves against it in as much as dealing with children is concerned. In fact, we have done a lot concerning the ethical issues in dealing with children. And we have also spoken about situations whereby you may be mandated by a court to give out information of a child and how to go about it. We also spoke about issues of touch, where you must be using your palm to be touching your client as a child, where we said the child should be given the pre-information, the reason why you are touching them. And it shouldn't be on any other motive apart from on living things that has outlived the child that go against their well-being. And we summarize that all these things we need to consider a potential improvement and not a harm on the child. And this ends the unit 3 of our lecture. Thank you and have a wonderful moment.